Bună dimineața, good morning! Bine ați venit la cea de-a doua ediție a Conferinței de Drept European a Afacerilor, o conferință pe care în mare parte o să o avem în limba engleză, dar vom avea anumite prezentări și în limba română. Le mulțumim tuturor celor care sunt prezenți aici în sală. Este o conferință în format hibrid, așa cum v-am obișnuit. Conferințele Facultății de Drept, cele internaționale în special, sunt în format hibrid. De anul acesta vom avea și două conferințe naționale organizate împreună cu facultăți partenere ale altor universități. Una va fi organizată aici la noi la ASE, o alta la Sibiu și acelea vor merge în format hibrid. Avem invitați de seamă, atât online cât și aici de față, și le mulțumim pe această cale că au acceptat invitația noastră. Încercăm prin această conferință să aducem atât speaker internațional, cât și personalități ale dreptului național, dar preocupați de dreptul european. Și, într-adevăr, la Facultatea de Drept avem o anumită secțiune, o anumită parte care este dedicată dreptului european. A fost în ultimii 20 de ani și chiar mai mult. Și aceasta ne oferă șansa de a interacționa cu partenerii noștri din străinătate, cadre didactice, dar și practicieni. Facultatea de Drept a demarat acest proiect în cadrul unei structuri mai complexe, respectiv una care ține atât de partea didactică cât și de cercetare. Așa cum am zis mai devreme, avem în predare unele discipline de drept al Uniunii Europene, fie că vorbim de dreptul instituțional, fie de cel material. Avem anumite discipline punctuale în anumite domenii și noi încercăm să dezvoltăm atât dezbaterea cât și componenta didactică. Avem în pregătire deja acreditat un master de drept european a afacerilor. Sperăm ca în 2 ani de zile să avem și proprii studenți la acest master și acesta, de ce nu, să fie ulterior transformat sau duplicat și într-o limbă străină. Ne gândim la o dublă diplomă pe studii de drept european a afacerilor. De asemenea, în cadrul licenței avem o disciplină de drept european a afacerilor care, de fapt, pregătește studenții care doresc să specializeze în acest domeniu, și alte discipline care sunt fie legate de piața unică, fie de alte componente de dreptul Uniunii Europene. Și consider că pe lângă partea didactică putem veni, și am venit de-a lungul timpului, componenta de cercetare, iar această conferință este unul dintre elementele acestei zone. Noi am avut de-a lungul timpului secțiuni în cadrul conferinței noastre de dreptul afacerilor care au fost dedicate dreptului internațional și în special dreptului european. Și am avut în cadrul departamentului nostru personalități ale dreptului europene care, pe lângă componenta științifică, respectiv manuale, cărți, au oferit lumii noastre academice și cursuri importante, fie aici, fie la alte universități, predate cu o legătură strânsă de această disciplină a dreptului europene, indiferent de generalitatea sau specializarea ei. Și aici menționau aici doar pe doamna profesor Lefte, care mi-a fost apropiată și care anul acesta va primi și o diplomă de onoare în cadrul sărbătorii celor 110 ani ai universității noastre. Așa că continuăm seria de evenimente dedicate dreptului europene, această zonă de cercetare, adăugând evenimente deja organizate în timp, o a doua ediție a acestei conferințe, și dorim prin aceasta, alături de cadre didactice, dar și de studenții noștri, să avem noi proiecte. Deja pe partea de cercetare avem câteva proiecte care au fost dedicate zonei digitale mai mult, dar cu apropiere de piața unică de digitală, și ne bucurăm că ai noștri colegi au ales să cerceteze în special în aceste domenii și sperăm să venim cu noi evenimente ceva mai punctuale și nu doar conferințe internaționale sau naționale, ci și dezbateri și workshop-uri care, într-adevăr, să trateze anumite subteme, să spunem, din această arie destul de largă. Le mulțumesc invitațiilor, o să trec și la partea de engleză, având în vedere că vom începe limba engleză. So welcome to the second edition of the Perspectives of European Business Law. It's a new conference that this faculty launched last year. We are pleased to welcome here in the campus some distinguished guests from abroad. Also, we have some online. We have also practitioners, scholars, students, some of them here, as you can notice, but also online. I want to thank them. For us, it's very important to promote this area of European law, and especially of European business law. In our faculty, in time, because we have been teaching mainly and researching European law at this department, faculty, for more than 20 years, we initiated different projects, and this is an area in which we develop both research and teaching. Just mentioning that we have some subjects that are taught at this faculty in strong connection with European law. We have even a master degree called European Business Law that we hope in 2 years when we'll have our own students, to actually have this master on the market. It is accredited, so we have it legally, just we need the students in order to start with it. Next to the master, we already started now in the second semester of a second year with a subject which is called European Business Law, and its introduction hopefully of the master to come, but also other subjects related to European law, either institutional law, of course, or material law in different areas. So the one that I just mentioned, we have one on European contract law and single market. We have also digital law with a component in this area. We have even fundamental rights, if you want, even if you go a little bit broader. So we have different subjects at Faculty of Law, so we are attracted and we hope that in time we can develop even more this area. Just from the area of teaching, I want to mention a person that this year will actually get a medal for her activity, and she's very close because she was the one coordinating me at the beginning, and she's a famous professor in European Union law, Mrs. Cornelia Lefter, and next to her, many others here taught in time at this university and other universities different courses of European law. So this just pointing out our interest and, of course, our involvement in the development of European, especially business law, at this new faculty created at the Bucharest University of Economic Studies. Next to the teaching, in time, we also involved in research. On the side of conferences, this is the second international conference, but in time we had sections in international and European law, of course, at the business law events that we organized. We have 13th edition of our conference in the autumn, and over there always we had us and our guests talking about matters in European business law. And yes, we developed this, and we want actually to develop more on the side of research, pure research. We have different projects. We have colleagues who initiated projects in, for instance, the digital single market, or others which are somehow connected to areas of European law. And we actually here at the Dean's office back them up in all these projects, and we hope we'll have in the future even more. And we hope that our professors, our colleagues, other professors in the teams, but also the students who started in the last years engaging in the research of European law, to come with new projects and to have them next to the already existing international or national conferences. As you noticed, we have this conference both online and face-to-face. So we have some guests here, but we have others online. This is something that we started, of course, in the pandemic, but we are pursuing with this. So all our conferences, international and national, are in a hybrid form. So that's why we hope that in time, the idea is that we'll actually develop this. And starting this year, we'll have even national conferences in a hybrid form. We'll have one now at Sibiu with our partners from there, in the autumn with the university from Alba Iulia, but here at ASE. So not saying more, but just an introduction on how we get involved in the European law and the special European business law area. And I want to thank everybody here and online for also getting next to us in this project and being part of this project. As you notice on the schedule, we have at the beginning some keynote speakers that I want to thank. Some of them came to Romania, some of them just visited us anyway from Romania and visited us here, and they allocated their time this day for the conference, and I want to thank them. And they will present some interesting issues. Hopefully we'll have some even debates after each part. What we do with the conferences, we have two parts. We have an opening session, we have the keynote speakers, and then we have an academic forum where we start debating on certain matters with the scholars and the practitioners in the field. And I want to thank and also invite first Mrs. Chantal Demol, a colleague, because I can say I'm co-teaching with Chantal a course here at our university. Clearly, we cannot teach for the moment, I suppose, in English at bachelor law, because law is still national. We say still because it's a conference of European law. Yeah. So maybe in time we'll change this, but the harmonization, or maybe even more, has to go deeper in order to talk about studies in European law in foreign languages at bachelor. At master, maybe yes, we can have by double the diploma. But we are teaching a certain subject, international contract law, and over there have an area of European contract law at a certain section, a certain MBA from our English sections. And next to the co-teaching, Chantal was involved in some other projects that we had in the last years, and I want to thank her by saying that it was our pleasure and also our honor to have her at the desk teaching, but also to have her insights on the projects that we developed in the last years. Chantal is a professor, have been for the last 26 years, if I'm not wrong, at Universitat de Barcelona, teaching civil law, but becoming very preoccupied with the area of European contract law, with common projects on unification of private law, but also with the consumer law, which we know already it's harmonized. So getting like this anyway got also to my area and also to some of my colleagues. So in that moment we found common grounds for the research and teaching. Chantal also is involved in consulting activity as a lawyer, mainly in civil law, also real estate, construction law, and she was involved in management activity, let's say, of some academic institutions. As I know, because I visited Barcelona and I was, anyway, not with her, with somebody else, I just was in a partnership over there and I found out about her being in a certain board. She was actually the director of a certain international master at ISDE. She was also a member of, she is a member of the civil law section of Barcelona Bar, director of the legal dissemination group, secretary of the Center for Research and Development, Real Estate and Commercial Property, also involved in the activity of the Association of Property and Commercial Registers of Spain. So you can notice she's involved in private and public projects, both academic and of practitioners. So thank you, Chantal, for attending our conference. Thank you for being this week with us, both in activity of teaching, but also now in research. Thank you.
Thank you very much. It's a pleasure to be here with you, and I really want to thank Professor Ovidiu to invite me. It has been a great opportunity to stay here all this week to meet business law students, law students, and I must say that I felt in love of Romanian people and of Bucharest and the history of Romania, and it has been a very, very great experience to be here, and I I hope that I can come back and strengthen this relationship with your university and with my colleagues. So, Professor Ovidio told me that I could speak about European issues. This week I made some lessons about consumer law, about professional careers, but today I would like to focus in a field which in fact is the one that was at the beginning of our relationship, which is construction law. And because we belong to this European Society for Construction Law, a society which was created just after Second World War. It is a very, I consider a very good project because it was after the war, Europe had to be rebuilt, and so French, German, Austrian, and professors from different universities in Europe decided to create this in order to make research and to think about the best rules for construction law. Now, unfortunately, we are living a war in Europe. Just here, I am very impressed not to see that it is so nearby. And, well, hopefully it will stop early. But after, we always need to rebuild, and construction is something good and something which can give economic growth. And Europe is very concerned on this. And they want, on the one hand, they want to promote energy efficiency, green economy, and also to boost the economy after the pandemics, and well, and also, of course, after the war. So I can't see, I don't know if I can, okay. So I prepare something in order that you can follow it, but maybe you cannot see the whole screen, no? Oh, yes. It's in green, and so it's difficult to read. I wanted to be green, but it's not very good for reading. Maybe, yes, I prefer. Yes. Okay, I can stand up. Or no? I sit down? Okay. Okay, so I called this speech Energy Efficiency and Renovation in European Building Sector. So here is the summary. I divided my speech to see the importance of the building sector to achieve energy and environmental goals. Then we will see which are the European regulations to boost energy efficiency in buildings. And then we will focus on this renovation wave for Europe, both strategy and action. And finally, I will comment a little bit what has been done in Spain. Okay, so the importance of the building sector to achieve European energy and environmental goals is clear. This sector is crucial. Think that buildings are responsible for approximately 40% of European energy consumption. 40%, almost a half. And 36% of the energy-related greenhouse gas emissions. Buildings are therefore the single largest energy consumer in Europe. Moreover, citizens consume in heating, cooling, and domestic hot water 80% of the energy. The 80% of their consumption is in these fields. At present, about 35% of the European buildings are over 50 years old, and almost 75% of the building stock is energy inefficient. And I want to comment that I enjoyed walking in your street in Bucharest, but I wanted to do this speech because I think that for Romanians, this program can be so useful, because you know that you have some buildings which are very beautiful, but unfortunately they are not refurbished, they are not renovated because of the lack of funds, because it's too expensive. So I do think this is an important program, and for business companies here, it can be very interesting to tender and to try to have to get in this strategy and action. Only about 1% of the building stock is renovated each year, so we have many opportunities to do. Of course, to have better energy efficient buildings also improve the quality of citizens' life, alleviate energy poverty, improves health, improves better indoor comfort levels, and it creates green jobs. Which are the European regulations? So we have mainly these two directives, you probably know them, of 2010 and 2012. One is more specific for performance of buildings, energy performance of buildings, and the other one is in general about energy efficiency. Their goal is to achieve a highly energy efficient and decarbonized building stock by 2050, to create a stable environment for investment decisions, and to enable consumers and businesses to make more informed choices to save energy and money. In fact, these directives, so now it's more than 10 years ago that they were approved, and it is considered that buildings consume only half compared to typical buildings from the 1980s. So there's already an effect. So these two directives of 2010 and 2012 have been amended in 2018 and 2019. I had the occasion to give a lecture at the European Commission in 2017 when all these amendments were being prepared. So these amendments are part of the package, you know, this energy policy framework to help us to move away from fossil fuels towards cleaner energy. And these amendments introduced new elements and show the strong political signal on the Europeans' commitment to modernize the building sector in light of technological improvements. And they want to increase building renovations. So from 1018, there's this idea of renovation. Just to mention, this directive has been transposed in Spain, and it had an effect on my field of law, private law, civil law, because, and I suppose that probably you transposed it, but for instance, just to give an example, from January 2023, all non-residential buildings that have a parking use area with more than 20 spaces, either inside or in an attached outdoor space, must comply with the requirement relating to the minimum endowments for electric vehicle charging infrastructure. So there are practical changes in national legislation. And afterwards I will comment another issue important also for private law. So let's see which is this renovation wave, this strategy and action. It was published in October 2020. The name is A Renovation Wave for Europe, Greening Up Buildings, Creating Jobs, Improving Lives. And it's a complete action plan with concrete regulatory, financing, and enabling measures to boost building renovation. The objectives is to at least double the annual energy renovation rate of buildings by 2030, to foster deep renovation, to create green jobs, as I said, and also to boost economic recovery after the COVID-19 pandemic. We must think that construction sector is largely dominated by local businesses, and building renovations can also play a crucial role in European economic recovery. But of course, we need that these small businesses arrive to the funds. The renovation wave identifies 3 focus areas. First, tackling energy poverty and worst performing buildings. Another is public buildings and social infrastructure. And finally, decarbonizing heating and cooling. These are the 3 areas. And so, the main question, how do we finance it? So, the renovation wave includes also a document which presents available EU funding budget solution that could support the renovation wave in different ways. Through direct investments, leveraging private investments, research and innovation, and to address market barriers and available technical assistance. I wanted to mention this plan that I put the link because I think it's not very well known, but if you can have a look, it's the new European Bauhaus initiative calls, which call on all of us, citizens, companies, to imagine and build together a sustainable and inclusive future that is beautiful for our eyes, minds, and souls. And it's written like this, no? It seems a poem, no? It seems romantic and utopic, but it's a plan. And they define what is beautiful. Beautiful are the places, practices, and experiences that are enriching, inspired by art and culture, responding to needs beyond functionality, sustainable, in harmony with nature, the environment, and our planet, inclusive, encouraging a dialogue across cultures, disciplines, gender, and ages. So, very good goals, no? But just to see that is something practical, I put a publication of October 2022, and there was an open call for innovative projects in cities. So the European Urban Initiative launched a 5 million euros call to support urban innovation and cities' capabilities to build a sustainable urban development based on the new European Bauhaus values. So it's a lot of money. This launch is thought more for urban cities, I mean for the town halls. But that's only an example, because there are prizes, there are also funds for businesses. So if you may have a look. Maybe it can be a useful information, and maybe you can fulfill the requirements. And just to end, a little mention to which are the rules which have been approved in Spain to transpose this amendment, this renewal plan. We had a new law in 2021 on climate change and energy transition, and well, that they want to use material with the lowest possible carbon footprints, improvements in the accessibility of buildings. They boost renovation, and they facilitate self-consumption photovoltaic installation in condominiums, and zero emissions heating and cooling systems. Another rule has been this of October 2021. This is more on financial issues, but also it amended our horizontal, our rule about condominiums, in flats, and the decision making by communities is facilitated in order to change heating systems or energy systems in the buildings. And finally, we have this recent law of 2022 on the quality of architecture. And in Article 2, they said that one of the purposes of the law is to increase the number of near-zero energy consumption buildings, not only in new construction, but also through comprehensive approaches in the renovation of the existing building stock. So I'm sure that you also have rules which in Romania which are implementing all this, and I think it is a very important plan of the European Union, and it can be very useful for Romanian businesses. So thank you very much for your attention.
Thank you, Chantal, on the insights, especially how Spain actually reacted to those. Now, if you have any questions from the room or online. Nothing? Now, just to extend a little bit the debate, I would address one. Now, taking into consideration what happens now and with the new strategies of European Union to get more independent from the energy point of view, if you see in the near future even new harmonization tools in this area, I mean, connecting what we have with the environment protection and the NZEB buildings and the new push anyway towards the new renewable energy or more renewable energy in order to get to a more independent Europe from the energy point of view. If you actually, this can go even further than now. We are now at the step of we transposed most of us, but now we have to put in progress, so we have to actually apply. If you actually can see just happen, for instance, in company or others, the push, meaning we have some directives, then we came with new ones. So we're in consumer, we had the minimum, and then we went to the maximum harmonization. If you can actually see in the new future, take into consideration the war, take into consideration the new events of new harmonization tools that actually may go to something else than we have now with this.
So your question is if I think it will go further.
And how fast? And that now we transposed, we're applying, but if we can actually, we have to do it even more than we have now.
Well, I know that the European Union, you see, the first directive 2010 and 2012, then an amendment 6 years later. 2 years later, well, we had the pandemic, 2020, the renewal strategy. So more or less, I think it will go faster and faster. Not periods of 8 years, but almost each 2 years we will have changes because, of course, it is also very related to technological improvement, and technology goes before law, no? And law is always after. And so I'm sure that we will have new issues, new regulation, and in fact they are already thinking at the European Union to change the amendments of 2018 and 2019. So it's interesting to be informed and to follow all these issues. And the European Union publish everything, so it's good to have a look to the website and to go to seminars like that in order to be informed.
Thank you. Now, if we thank you, Chantal, for the, as I said, insights and for your work, especially here at our faculty, but also in Barcelona. I have to mention that with Chantal, we established a partnership with the Universitat de Barcelona on Erasmus program. When I was a student here as an economist, a future economist anyway, I applied. Even if I didn't go to Barcelona because I decided to start a project in Romania, we had at that time, so I'm speaking about 2000, and for many years we had no relation with Barcelona from the Erasmus point of view, maybe others. So we re-established this, and we are thankful to Chantal and also the Vice Dean and the Dean over there for opening the door for our very young faculty. Thank you, Chantal. And now we switch from, anyway, connected to the market in a way or another, but we switch from this area of construction to competition, as I understand, and not anything in competition, but actually a judicial part with the title French judge and the state age. The next speaker came especially for this conference to Romania, and we want to thank him for that. We have here Jérôme Sanjou de Berge de Salut, Judge Rapporteur, the litigation section at the Council of State, expert in legal affairs at the French Ministry of Foreign Affairs, member of the Council of State of France, and former government agent of France at the Court of Justice of the European Union, if I recall right. Thank you for your presence here. Thank you for preparing, and I'm pretty sure it will be interesting debate after the presentation, and also maybe during the break with our colleagues here in the room. And we hope to see you more and more at our events. Thank you.
Oh, thank you. Thank you, Mr. Dean. It's a great honor for me to make, for the first time, a presentation in the law faculty of this academy. And as has just have been said, I'm due to talk to you about the French judge and state aid, and I realize that my presentation will supplement the presentation of Judge Onisho. Just a few words, introductory remarks, before giving you some recent examples of cases dealt by the French Conseil d'État on state aids. So it's not to minimize the role played by national courts in the field of state aid, to start by recalling that its role is limited by the powers conferred on the European Commission by the treaties. And as you know, the Court of Justice speaks of complementary but distinct roles. Thus, national courts may be seized of disputes requiring them to interpret and apply the concept of state aid with a view to determining whether or not a state measure introduced without taking account of the prior control procedure by the Commission should be subject to it, and if so, to order its recovery. However, these courts, as you know, are not competent to rule on the compatibility of the aid measures with the internal market. This assessment falls within the exclusive competence of the European Commission of course, acting under the control of the EU courts. However, the relatively limited but also highly regulated jurisdiction of national courts should not conceal the quantitative importance of state aid litigation before national courts, and namely before French administrative courts. To give you some figures, since the beginning of the year 2000, there have been approximately 3,700 administrative court of first instance judgments, 1,800 administrative court of appeal rulings, so referring to state aid. And as for the French Conseil d'État, which is the supreme administrative court in France, it has issued about 200 decisions dealing with state aids since the years 2000. A final clarification before turning to recent case law. I refer to French administrative courts and not to French courts. And the reason why is because, as you probably know, the organization of administrative justice in France is different from the organization of administrative justice in Romania. Whereas in Romania, of course I'm talking under your supervision, but in Romania there's only one jurisdictional order. In France, we have two, namely the judicial jurisdictional order and the administrative jurisdictional order. This dualism is not unique to France, as you know. It can be found in many EU member states, such as Austria, Belgium, Netherlands, Italy, Poland, Bulgaria, and in Germany, as you probably know, there are five jurisdictional orders, and not only two. Let's turn now to the recent case law. Following the pollution caused by the sinking of the Erika tanker in 1999, the French government took measures in favor of fishermen, consisting of a 50% reduction in the employer's share and the employee's share of social security contributions for a period of 6 months in the year 2000. In a decision of 14th of July 2004, the European Commission found that these measures constituted incompatible aid and ordered the French authorities to recover them. So the Compagnie des Pêches de Saint-Malo applied to the Administrative Court of First Instance to have the collection order issued by French authorities annulled insofar as it concerns the reductions of employees' contribution, not employers' contribution, but employees' contribution, holding that the actual beneficiaries of the reduction in the employee share of social contributions were not the fishing companies, but their employees. And that's why the two courts, the Administrative Court of First Instance and the Administrative Court of Appeal, ruled in favor of the undertaking. But on the appeal of the Minister of Agriculture before the French Conseil d'État, so the Supreme Administrative Court, the Council of State decided to stay the proceedings and to refer the matter to the Court of Justice for a preliminary ruling. And in a judgment of 17th of September 2020, Compagnie des Pêches de Saint-Malo, the Court of Justice ruled that the Commission's decision of 14th of July 2004 was invalid. It's quite rare for the court to rule that the decision of the Commission is invalid in the framework of the preliminary ruling procedure, was invalid insofar as it qualified as state aid incompatible with the treaty, the reduction in employees' contribution granted by France to fishermen. According to the Court of Justice, it's common ground that employees' contributions are not borne by the fisheries undertakings in their capacity as employers, but are payable by the employees. Those undertakings, according to the Court of Justice, are only required to deduct those contributions from the remunerations of their employees on each salary slip with a view to paying them to the competent social security body. Thus, according to the Court of Justice, the measure reducing the employees' contributions at issues remains neutral in relation to the undertakings and their employees, to the undertaking, and their employees are the actual beneficiaries of the reductions at issues. Nevertheless, in its judgment, the Court of Justice didn't rule out the possibility that aid whose direct beneficiaries are the employees of an undertaking may constitute indirect aid granted to the undertaking itself. However, the court noted that neither the contested decision of the Commission nor the file before the court contained any indication that the undertakings concerned had benefited indirectly from state aid. Moreover, it was clear from the contested decision of the Commission that the advantage relied on by the Commission consisted for the undertakings not of an indirect, but of a direct effect. A second case, which is quite interesting, before the French Conseil d'État during the recent years on state aid, it's interesting because the Court of Justice has given very few rulings on amendments to aid schemes already approved by the Commission. And so a case, the SAS Carrefour hypermarket case, was of interest, firstly because of the question referred to the Conseil d'État, to the Court of Justice by the Conseil d'État for a preliminary ruling on this topic, but it was also interesting because finally the court's answer ultimately proved to be of no use for resolving the dispute. Sorry. So the case concerned a film, an audiovisual aid scheme approved by the Commission and financed by three taxes: a tax on cinema tickets, a tax on television services, and a tax on sales and rentals of videograms. In order to obtain reimbursement of the tax on sales and rentals of videograms that they had to pay, several companies, including Carrefour, the very famous hypermarket society, brought an action before the administrative court. These companies argued that the aid scheme in question should have been subject to a new notification to the European Commission insofar as the revenue, the proceeds from the taxes, increased considerably between the decision of the Commission and the year 2011 by almost 60%. The revenue from the tax on television services alone, which is payable by television publishers and distributors, rose from 262 million euros per year to 631 million euros, within 7 years. However, while the European Commission authorized the change of the tax base in 2007, its decision was based on much more limited forecast of the increase in tax revenue provided by the French authorities. And the problem for the French Conseil d'État was that there's an article in a Commission regulation of 2004 which provides very specifically that an increase in the initial budget of an existing aid scheme, so authorized by the Commission, shall not be considered to be an alteration to the existing aid if it doesn't exceed 20%. So this time it was 60%, so 20%. Alors, so why the French Conseil d'État decided to refer a question to the Court of Justice in spite of this regulation? And the reason why we decided finally to question the court, we have much debate about that, was that notifications to the commissions are prior in nature. How can the Commission so be notified of an increase in a tax above 20%, financing an aid scheme when this sharp increase, of course, will be noted afterwards, after the fact? Moreover, this sharp increase could be only temporary, just, for 1 year. Should we then wait until this sharp increase is permanent before notifying to the Commission? And another question, it often happens that part of the proceeds of the tax is set aside or deducted for the benefit of the state budget and not so giving to the undertakings. So in this case, should the increase in question be assessed in relation to the proceeds of the tax or in relation to the aid actually paid out? However, in its judgment of September 2018, the Court of Justice stuck to a strict reading of Article 4 of the regulation of the Commission, holding in particular that the 20% threshold is to be assessed in relation to the revenue assigned to the aid scheme and not in relation to the aid actually granted under that scheme to the undertakings. But nevertheless, the victory of Carrefour and its co-applicants was not so certain. Indeed, in its judgment, the Court of Justice first took the trouble to recall its case law, according to which, for a tax to be considered an integral part of an aid measure, there must be a binding link between the tax and the aid concerned, in the sense that the proceeds of the tax are necessarily assigned to the aid and directly influence the amount of the aid. And the court, which in this case have clearly doubts in this respect about the direct link between the tax and the aid, invited the French Conseil d'État to verify its premise that the three taxes in question were an integral part of the aid scheme. And so, a year later, in 2019, after having received the answer of the Court of Justice, the French Conseil d'État, in its final decision, concluded that there was no such binding allocation link, since a significant part of the proceeds of the tax was placed in reserve, and another part was subject to deductions for the benefit of the state budget and was therefore not allocated to the film and audiovisual aid scheme. So in the end, the preliminary question proved interesting but unnecessary. A third case, which is quite interesting, without a reference case to the Court of Justice, but a decision by the French Conseil d'État, it's a decision of 7th of June 2017, Société Le Muselet-Valentin. In this decision, for the first time, le Conseil d'État français ruled that the obligation for a company receiving state aid declared incompatible with the internal market by the Commission to repay this aid and pay interest cannot engage the responsibility of the state. It's true, according to the French Conseil d'État, that the French state was at fault for having first paid aid that was subsequently declared incompatible with the common market by the Commission, and also, in this case, for having delayed in recovering the aid and so demanding interest. But because the French authorities delayed the recovery of the aid, and of course the undertaking had to pay interest because of this delay since the granting of the aid. But according to the French Conseil d'État, there's no causal link between the fault of the French authorities and the damage suffered by the company, since by virtue of its EU obligations, France was required to recover the aid and to attach default interest to this recovery in order to compensate for the financial and competitive advantage provided by the aid. And so the solution of this decision of the French Conseil d'État seems to me hardly questionable, since according to the case law of the Court of Justice, as you know, no company, however small it is supposed to be unaware of the law on state aid, and so a company must only blame itself if it has to repay incompatible aid. However, while the company receiving incompatible aid cannot hold the state liable for that, this is not the case, of course, for a competitor of this company, which has suffered competitive damage of the result of the incompatible aid. But the possibility for a competitor of a company receiving an aid declared incompatible with the common market by the Commission, the possibility to effectively challenge the liability of the state or the public authority having granted the aid is a long-standing problem. Also, the Court of Justice and the European Commission have long been calling for this type of action. It must be admitted that it's very difficult for a competitor to demonstrate that the incompatible aid is responsible for a reduction in its commercial activity. However, this possibility of compensatory action has recently become a reality in France in the context of two legal sagas. The first sagas involved for many years two maritime companies providing passenger transport between mainland France and the island of Corsica. This legal saga, which has occupied both the EU courts and the national courts, has opposed the Société Nationale Corse Méditerranée, acronym SNCM, which was a public company because now it's in liquidation, against Corsica Ferries, which is a French company, but with English name, a French company, but which is a private company. By a decision of 2013, the European Commission qualified as state aid incompatible with the common market the financial compensation paid by the Corsican Regional Authority to SNCM for a so-called additional service provided by this company for 6 years, between 2007 and 2013. This additional service consisted of the operation by the maritime company, by SNCM, of 2 car ferries during peak periods between the port of Marseille on the mainland and 3 Corsican ports, but in competition with the lines operated by Corsica Ferries between mainland and Corsica and those ports. Following this decision, the Corsica Ferries companies asked the Administrative Court of First Instance of Marseille to order the Corsican Regional Authority, no, it was not the national state, but the regional authorities, to pay it the sum of 88 million euros with interest as a legal rate as compensation for the damage caused to it by the operation of the so-called additional service for this period, and of course of the aid granted for this additional service. And in a judgment of 2017, which was the first in France of this type, the Administrative Court of First Instance ordered the Corsican Regional Authority to pay Corsica Ferries a sum almost 85 million euros, so a little bit less, but 85 million euros with interest as a legal rate from the granting of the aid in 2014. In particular, the Administrative Court of First Instance considered that the Corsican Regional Authority did not seriously dispute that if the additional service has not existed, so financed by the aid, Corsica Ferries would have been able to improve the capacity of its ships on the routes concerned. In assessing the loss, the Administrative Court of First Instance based itself on the assumption that about 70% of the passengers which used the additional service of SNCM would have switched to the routes operated by Corsica Ferries. So this was the first assumption of the court. And the second assumption was the fact that there would have been the Corsica Ferries company would have been able to absorb this increase in traffic without increasing its fixed costs. And in a judgment of 2021, the Marseille Administrative Court of Appeal, after ordering an expert appraisal to determine the amount of compensation, but finally the Court of Appeal confirmed in substance the judgment of the Court of First Instance. But the Corsican Regional Authority lodged an appeal against the judgment, the ruling of the Court of Appeal before the French Conseil d'État. But in a decision of 2021, at the end of the year, the Conseil d'État rejected the appeal of the Corsican Regional Authority against this judgment. So finally, the Corsica Ferry Company was given 85 million euros, so for a compensation of the state aid incompatible with the common market paid out to the SNCM. And a second case, a second saga, is a very different saga. In a judgment, so I will go directly to the ruling of the Court of Appeal, but the Paris Administrative Court of Appeal, in a ruling of 2019, ordered the French state, this time it was the French state, to pay the Société Internationale de Diffusion et d'Édition, CID in the French acronym, compensation of 10 million euros for aid paid by the state to the Coopérative d'exportation du livre français, CELF, from 1981 to 2001 for 20 years. They've been paid out for 20 years to encourage small orders of books from bookshops located abroad. Because, small orders of books cost a lot, for the publisher. And so there was an aid for 20 years, to encourage, of course, the delivering of these books from to the small bookshops abroad, of course, to encourage, of course, the French language. And as this aid was finally declared incompatible with the internal market by the European Commission, the state, according to the Court of Appeal of Paris, committed a fault likely to engage its responsibility towards CID, which was CELF's only competitor. And in the decision of 22nd of July 2020, the Conseil d'État rejected the appeal of the Minister of Culture against this ruling. So this time it was not 85 million euros, but 10 million euros. So it's also interesting, another procedural topic which is quite interesting, is that the Paris Administrative Court of Appeal, before giving its judgment, had called on the European Commission to provide guidance based on a communication by the Commission of 2009 concerning the application of stated rules. In this notice of 2009, the Commission states that questions concerning the determination of damages may also be the subject of request for assistance addressed to the Commission by national courts. And this assistance, according to this communication, may take the form of the provision of factual data, statistics, market studies, and economic analysis by the Commission to the national judge. And this power is now enshrined in Article 29 of a regulation on state aid of 2015, which empowers national courts to request the Commission to provide information in its possession or an opinion on questions concerning the application of stated rules. So, it's a very large possibility. Another detail which is quite interesting is that Article 29 also empowers the Commission to submit on its own initiative written observations to national courts on its own initiative. For a long time, the member states were very reluctant to give this possibility to the Commission. I remember we refused the Commission to submit written observations before national judges. But finally, in 2015, we decided to allow the Commission to do it. So it's quite rare, but at least there's one case in France before the Court of Appeal, Administrative Court of Appeal of Bordeaux, in a case, another saga, the Ryanair saga, state aid, and in 2014-15, the Commission, on its own initiative, submitted written observations before the Bordeaux Administrative Court of Appeal. So, to conclude, which is very interesting, is that what is called the private enforcement of state aid is probably at its beginning, but very probably this, what is called private enforcement of state aid, it means not by decisions of the European Commission, but by initiatives of competitors, of course, of the beneficiaries of aid declared incompatible with the common market by the Commission. I'm sure that this private enforcement is set to grow in the coming years. Thank you very much.
And yes, we plan somehow to have both perspectives somehow on this, in the idea that the next speaker actually has a similar title or a similar approach on this, but with the Romanian side, let's say. So next we have Judge Amelia Onișor from the Bucharest Court of Appeal, also trainer at the National Romanian Institute of Magistrates. I think over there with the subject judicial cooperation in civil matters. And I think it's also about remedies in matters of state aid. So maybe after we'll have a debate between the two jurisdictions.
First of all, I would like to thank you for the beautiful presentation, very thoroughly and detailed presentation. Thank you, and I always have a great interest as an administrative judge, of course, not in the sense of the French legal system, but still an administrative judge in your topic, and also the topic that you have presented, because I have a specialization in public procurement, and it is quite intertwined with the topic that you mentioned. So thank you, and it was a pleasure to be present here. I will switch to Romanian. Is it okay?
Yeah, it's okay to have that, and at the end we can actually see exactly how we can debate on this.
Yeah, sure. And I can conclude in English at the end of the presentation.
Thank you.
Mulțumesc mult pentru invitație. E o onoare să fiu aici alături de dumneavoastră la un eveniment care pare să fie deja de succes. Sunt convinsă că așa se va contura până la final. Voi vorbi astăzi despre remedii în fața instanțelor naționale în materia ajutorului de stat. O prezentare, cred că nu este, nu e foarte clar vizibilă acolo pe ecran. Poate dacă se mai pot face niște ajustări tehnice, să fie zoom out un pic. Dacă nu, cred că ne putem descurca și așa, nu?
Online oricum se vede prezentarea care o aveți, cea de acolo. Da.
Acum e mult mai bine. Mulțumesc. Abordăm niște principii generale la început, pentru că e foarte important să avem o imagine foarte clară în ceea ce privește competențele pe care le împart Comisia, instanțele naționale, și, pe de altă parte, și Curtea de Justiție. Vom avea o discuție și în legătură cu competențele pe care le are Curtea de Justiție în acest domeniu. Comisia are această competență exclusivă de a aprecia, în primul rând, asupra notificării măsurilor care pot constitui ajutor de stat înainte de implementarea lor de către statele membre. Deci o apreciere ex ante pe care o face doar Comisia. De asemenea, apreciază asupra compatibilității ajutorului de stat cu piața internă, în temeiul articolelor 107 alineatul 2 și 3 din TFUE și 106 alineatul 2 din același tratat. Analizează și investigează plângerile pe care terții le pot formula în legătură cu ajutoarele de stat ilegale și incompatibile cu piața internă. Există de asemenea și niște competențe partajate între Comisie și instanțele naționale. Ambele pot aprecia asupra calificării măsurilor de stat ca fiind ajutoare de stat în temeiul condițiilor prevăzute la 107 alineatul 1 din Tratatul privind funcționarea Uniunii Europene. Sunt acele condiții pe care le cunoaștem cu toții și care sunt analizate atât de Comisie cât și de instanțele naționale, dar și de Curtea de Justiție atunci când face o analiză în privința ajutoarelor de stat, de exemplu atunci când interpretează articolul 107 alineatul 1 în temeiul unei cereri de trimitere preliminară. Mai precis, se verifică dacă este vorba despre o întreprindere, noțiunea de întreprindere însăși are un sens autonom, dacă există un avantaj economic în favoarea unei astfel de întreprinderi, avantajul este acordat de stat sau prin intermediul resurselor statului și dacă acest avantaj este selectiv, un lucru foarte important pentru toată această apreciere a noțiunii de ajutoare de stat. De asemenea, iarăși o chestiune extrem de importantă dacă ajutorul de stat are consecințe asupra concurenței din piața internă. De asemenea, atât Comisia cât și instanțele naționale analizează împrejurarea dacă măsura trebuia să fie notificată sau nu. Avem un bogat soft law aici, s-a făcut referire mai devreme și în legătură cu acele comunicări ale Comisiei. Comisia are mai multe comunicări interpretative în domeniul acesta al ajutoarelor de stat și chiar și o comunicare în ceea ce privește rolul instanțelor naționale, o comunicare destul de nouă, din 2021. Am contribuit puțin și eu la acea comunicare, în sensul că am fost reprezentantul României în cadrul dezbaterilor avute de comisie pentru, de fapt, îmbunătățirea unei forme mai vechi a acelei comunicări interpretative. În privința instanțelor naționale, ele au, de asemenea, o competență exclusivă în anumite domenii, cum ar fi în legătură cu remediile și cererile de despăgubire ale terților afectați de punerea în aplicare a unei măsuri de ajutor de stat și ele pot decide asupra suspendării măsurilor legale sau recuperarea ajutorului de stat, indiferent dacă acest ajutor de stat este sau nu compatibil cu piața internă. Ceea ce este esențial este să fie considerat ilegal. De asemenea, există posibilitatea ca instanța națională și, de fapt, doar instanța națională poate să ia măsurile provizorii pe care un terț le poate solicita într-un caz dat. Poate o instanță, de asemenea, să dispună acordarea de despăgubiri în favoarea terților, în special competitorilor beneficiarilor de ajutoare de stat. Aceasta este tabloul competențelor partajate între Comisie și instanțele naționale. Faptul că Comisia Europeană are competență exclusivă de a se pronunța asupra compatibilității unui ajutor de stat cu piața internă, o știm dintr-o jurisprudență care este constantă și care a început cu mult timp în urmă, până în zilele noastre, aș zice. Această cauză, care este relativ recentă, are mai puțin de un an, e o cauză care privește noțiunea de ajutor de stat nou. Ce înseamnă ajutor de stat nou? Atunci când avem deja o schemă de ajutor de stat care a fost deja aprobată de către Comisie. În cauză era vorba despre niște microcentrale hidroelectrice de folosire individuală. Și se punea problema dacă, în momentul în care a expirat acea schemă de ajutor de stat și în măsura în care statul național menținea acele măsuri favorabile pentru anumite întreprinderi, putem considera că acel ajutor este un ajutor existent sau este un ajutor nou. Și Curtea de Justiție a precizat că este, de fapt, un ajutor nou. El trebuia notificat, din nou, ceea ce nu s-a întâmplat în cauză, dar cu ocazia acelei analize a reamintit Curtea acest principiu foarte important, că e de competența exclusivă a Comisiei să aprecieze compatibilitatea unor măsuri de ajutor de stat cu piața internă, în timp ce instanțele naționale asigură protecția drepturilor justițiabilor în cazul încălcării obligației de notificare prealabilă la Comisia Ajutoarelor de Stat. Instanțele, CJUE, că vorbeam puțin mai devreme despre acest lucru, are, bineînțeles, niște competențe care îi sunt atribuite prin tratat și sunt destul de clare. Analizează acțiunile directe care pot fi îndreptate împotriva, de exemplu, deciziei de constatare a unui ajutor ca fiind ilegal și incompatibil cu piața internă. În temeiul 263 din Tratatul privind funcționarea Uniunii Europene, evident, acest lucru se întâmplă în primă instanță de către tribunal, analiza se face de către tribunal și recursul la Curtea de Justiție. De asemenea, în temeiul acelei proceduri a trimiterii preliminare, dacă există un proces care să fie pendinte în fața instanțelor naționale și dacă se pune problema validității deciziei Comisiei în legătură cu ajutorul de stat, evident, instanța națională nu are competențe în acest sens și știm asta de la Fotofrost încoace și atunci, dacă există un astfel de dubiu, trebuie ca instanța națională să sesizeze, indiferent de gradul său, să sesizeze Curtea de Justiție pentru a se pronunța asupra validității deciziei. De asemenea, CJUE interpretează noțiunea de ajutor de stat atunci când este sesizată de instanțele naționale în același temei, 267 din tratat, dar, bineînțeles, e vorba aici de trimiteri preliminare în legătură cu interpretarea unei norme de dreptuie. Este clar, așa cum precizam mai devreme, că și instanțele naționale au această posibilitate de a analiza noțiunea de ajutor de stat atunci când vom vedea, sunt puse în fața unei acțiuni, de exemplu, de despăgubiri pentru că s-a încălcat obligația de standstill. Pentru instanțele naționale, decizia Comisiei este obligatorie în ceea ce privește evaluarea cu privire la existența unui ajutor de stat. Instanțele naționale trebuie să se abțină de la pronunțarea unei hotărâri contrare unei decizii a Comisiei. Evident, ele au marja de apreciere de a formula o trimitere preliminară în temeiul articolului 267 din TFUE, cu cele două distincții referitoare la interpretare versus validitate, în sensul că la validitate, atunci când există un dubiu, trebuie necesar, în mod necesar să sesizezi Curtea de Justiție. Altfel, dacă ești instanță de ultim grad și ai astfel de dubii, iarăși ești obligat, o obligație care nu este absolută, după cum știm din jurisprudența de la CILFID până la Consorțiul Italian Management. M-am gândit să împart, practic, aceste remedii și analiza în sine a remediilor în fața instanțelor naționale în funcție de cele două ipoteze, dacă avem o decizie a Comisiei sau dacă nu avem o decizie a Comisiei. Dacă Comisia a emis o decizie prin care a declarat ajutorul ca fiind compatibil, aceasta nu înseamnă că ex post facto s-a regularizat ajutorul în sine, măsura de punere în aplicare a ajutorului, pentru că, în principiu, s-a încălcat această obligație de notificare care era obligatoriu de realizat în cazul dat și, prin urmare, de exemplu, pentru recuperarea prejudiciului în urma încălcării acestei obligații de standstill, este posibil să se facă o astfel de analiză. Curtea de Justiție, în cauza care a fost discutată puțin mai devreme, Self, referitoare la acel ajutor, acele măsuri acordate unei societăți franceze în legătură cu broșurile, cărțile pe care le trimiteau în străinătate pe bani destul de puțini, aveau nevoie de o susținere din partea statului și această măsură a fost analizată de Curtea de Justiție. Curtea de Justiție a precizat că decizia finală a Comisiei nu are drept consecință a face conforme cu legea a posteriori actele de executare care nu erau valide, pentru motivul că fuseseră adoptate cu încălcarea interdicției prevăzute la acel articol. Și ați aflat deja că litigiul era destul de complex, Comisia a analizat deja a treia oară această chestiune. Oricum, concluzia era în sensul pe care l-am prezentat-o anterior, că faptul că e compatibil un ajutor de stat nu înseamnă că nu s-a încălcat acea obligație de standstill, prin urmare nu există un prejudiciu care trebuie să fie acoperit. La fel și în Arriva Italia și alții, li se amintește instanțelor naționale că obligația de a avea în vedere toate consecințele unei astfel de încălcări în conformitate cu dreptul național, atât în ceea ce privește validitatea actelor de punere în aplicare a măsurilor de ajutor, cât și recuperarea asistenței financiare, este foarte importantă. În ipoteza în care avem o decizie de inițiere a procedurii, deci nu o decizie care să analizeze compatibilitatea ajutorului de stat încă, ci doar o inițiere a procedurii și procedura este pendinte la comisie, instanța națională nu poate considera că această măsură nu constituie ajutor de stat, nu poate să mai facă o astfel de analiză câtă vreme s-a demarat această procedură de către comisie și ea poate decide fie să suspende punerea în aplicare a măsurii în cauză și să dispună recuperarea sumelor deja plătite, fie să ia niște măsuri provizorii pentru a asigura protecția intereselor părților în cauză, evident și eficacitatea deciziei Comisiei privind inițierea procedurii. Ceea ce nu se poate face, și acest lucru este clar determinat, nu se poate suspenda cauza. Ești sesizat cu o cauză, de exemplu, ca instanță națională, în legătură cu repararea prejudiciului cauzat ca urmare a încălcării obligației de standstill. Nu poți suspenda cauza până când se pronunță comisia cu privire la natura ajutorului. De ce? Pentru că aduce atingere în felul acesta drepturilor terților în principiu și asta ni se spune și în această cauză self. Este foarte comod pentru instanțe nu să suspende o cauză și să aștepte acest lucru, pronunțarea, către comisie cu privire la compatibilitate, dar este complet interzis, aș zice, și produce la rândul său prejudicii terților. În ceea ce privește ipoteza a doua, absența unei decizii a comisiei, instanța va trebui să analizeze propriu motu, practic, cele trei chestiuni. Unu, dacă acea măsură îndeplinește condițiile pentru a fi considerată ajutor de stat și analizează potrivit interpretării date articolului 107 alineatul 1 din TFUE în jurisprudența CJUE în special. Dacă acea măsură face obiectul obligației de standstill, pentru că sunt niște exceptări, cum ar fi în privința ajutoarelor de minimis, de exemplu, dacă vorbim despre ajutoare, măsuri acordate de cel mult 200.000 de euro pe parcursul la 3 ani, cu privire la aceeași întreprindere, atunci această obligație de standstill practic nu există în legătură cu măsurile respective. De asemenea, trebuie să ia măsuri și să cerceteze, dacă e cazul, să ia măsuri corective adecvate pentru a asigura protecția drepturilor terților afectați de o astfel de încălcare. Ajutor nou, am vorbit puțin mai devreme ce înseamnă în contextul acesta când acorzi un ajutor pe o anumită perioadă și după expirarea schemei aprobate, dacă le acorzi în continuare, e vorba tot despre un ajutor nou care trebuie notificat comisiei. De asemenea, modificarea unui ajutor existent este tot un ajutor nou, pentru că atunci când a făcut o analiză comisia asupra compatibilității, a luat în considerare toate elementele care sunt proprii acelei măsuri și dacă ai schimbat ceva, care era esențial, evident, o nouă analiză trebuie realizată de către comisie. Ziceam despre ajutoarele de minimis care sunt exceptate și mai există și exceptări pe categorii. Acum, în perioada pandemiei, au fost foarte multe exceptări în această privință, care nu sunt sau nu trebuie să urmeze această cale a notificării. O decizie de la Înalta Curte de Casație și Justiție în legătură cu aceste noțiuni și ceea ce înseamnă, de fapt, ajutor de minimis, obiectul acțiunii era anularea deciziei de recuperare a unei sume care era superioare valorii de 200.000 de lei, cred că era euro, de fapt, și era vorba despre niște măsuri acordate de Centrul Național al Cinematografiei. Tot această instituție a emis o decizie pentru a recupera sumele respective, pentru că a constatat că, de fapt, pe parcursul celor 3 ani fiscali cu privire la acea întreprindere a fost acordată o sumă care era superioară valorii maxime pentru ajutoare de minimis. Ei, în instanță, au contestat și acest lucru, că n-ar fi putut chiar instituția, organul care a acordat acel ajutor de stat prin unilateral, practic, să decidă recuperarea ajutorului pe care tot ea l-a dat. Însă, în Alta Curte de Justiție a spus că este perfect realizabil acest lucru și, de altfel, e chiar o obligație pe care o are o astfel de instituție să recupereze sumele avansate. Acțiunea a fost respinsă, prin urmare, a fost o acțiune în contencios administrativ pentru că depășea acel prag de minimis. Mai am puțin timp? Sau? Ok. În privința obligației de standstill, o altă hotărâre de la Curtea de Apel Constanța, de altfel, aici au fost mai multe hotărâri în același domeniu, referitor la la despăgubiri solicitate pentru pretinsa încălcare a obligației de standstill privind organizarea serviciului de pilotaj al navelor maritime și fluvio-maritime. Aici, instanța analiza, practic, dacă sunt îndeplinite cerințele de la 107 alineatul 1 din TFUE, dacă sunt toate elementele ajutorului de stat prezente cu privire la acele măsuri și a constatat că nu, în mai multe rânduri, în mai multe cauze similare, ziceam, pentru că, de fapt, acel serviciu nu ar afecta concurența pe piața liberă, ar fi fost ceva ce ținea de monopolul statului, nu era deschis pieței libere. În ceea ce privește, de fapt, doar să concluzionăm, în faptul că instanțele naționale trebuie să le ofere justițiabilor certitudinea că vor fi luate toate măsurile corespunzătoare în conformitate cu dreptul lor intern și ceea ce mi se pare extrem de important este acest lucru legat de autonomie procedurală. Putem să facem tot ceea ce este permis în dreptul nostru național, în special în dreptul, de fapt în dreptul procedural, dar cu cele două limite, să nu aducem atingere eficacității dreptului Uniunii Europene și nici principiului echivalenței, în sensul că să nu acordăm mai puține drepturi sau drepturi care sunt restrânse în comparație cu cele care derivă din dreptul național, pentru că acestea sunt drepturi care derivă din dreptul Uniunii Europene și trebuie să existe o balanță între, inclusiv între pârghiile procedurale care sunt recunoscute pentru ambele, pentru drepturile din ambele surse. Mulțumesc mult! I can conclude also in
English. Yeah, just to connect this one with the other presentation, if possible. Yeah.
Okay. So, what I have stated here, it is related to the remedies that the national courts can take related to the state aid, and we have seen a lot of cases from the Court of Justice of European Union, also the case that you mentioned, the SELF case, because it is quite interesting and important in all this matter of state aid. And also we had several national cases related to the analysis that the national courts have made regarding the concept of the state aid based on Article 107, paragraph 1 from the Treaty of European Union, functioning of European Union. So the national courts, actually in Romania, we don't have, a very large case law related to this problem, because in general, the parties are quite skeptical formulating actions before the Commission state about this state aid, if it is compatible or not with the internal market. But nowadays, I think we have 2 or 3 years since we, at least at the Court of Appeal in Bucharest, but also in Constanța and some other courts, that we have dealt with such cases. And in general, I think in 90% of the cases, the problem related to the interpretation of the notion of the concept of state aid appears. So, and the national courts just do that, ask the Court of Justice to interpret the notion when they deal with such cases, even though they are not judging in the last instance, because in Romania, the Court of Appeal can judge in first instance in administrative cases related to the decisions, for example, from certain bodies or institutions from our country. And in the end, we have stated, especially related to the procedural autonomy, that we have to be very careful to give all the parties all the rights that derive from EU law, taking into consideration the two limits of procedural autonomy. Thank you so much.
Thank you. Now, some other conclusion, those two, or any questions? Is it okay? Now, because we have a break and have 20 minutes left, we should actually get to the last presentation. We have here present Mr. Laura Litsu, Cabinet Director at the Government Agent for the European Court of Justice Office. And she has a degree in international law and a complex activity in matters of EU law, tax and competition. And today area it's related on this aspects. Thank you for coming at our conference and offering again on these sites, on these issues, your opinions. I think also the presentation is in Romanian, yeah?
I will try to speak in English. I think
okay.
I can try that. Thank you so much for inviting me and for the introduction. Indeed, I will try to touch upon a recent case law of the CJEU in a request for preliminary rulings referred by Romanian national courts in the field of tax law and competition, but I will try to steer clear of state aid. As mentioned in the presentations before, the preliminary ruling is a mechanism provided by Article 267 of the Treaty on the Functioning of the European Union, TFEU, which in essence allows national courts, when they deem that an interpretation of EU law is necessary for them to solve a dispute brought before them, it allows them to ask the CJEU the relevant question. In both fields, which I will be touching upon today, the CJEU's case law is quite rich, as you could have probably have already seen, and especially in tax law, which is responsible for about 30%, I believe, over the past years of the total of CJEU rulings in preliminary rulings. So, to start, I will briefly approach a very recent judgment that the court released 2 weeks ago on the 2nd of March in case C-394 of 2021, Bursa Română de Mărfuri. Just a moment, please. The national litigation, which gave rise to this case that touches upon both energy law and competition. I will try to be briefer on the energy part. Concerned the refusal by the National Regulatory Authority in the field of energy to issue a license to Bursa Română de Mărfuri, a company integrated in Romania, to issue a license for it to organize and operate centralized electricity markets. This refusal was based upon a national legislation which is no longer in force in Romania. Article 10, paragraph 2, letter F of Law 123 of 2012 on electricity and natural gas, which provided that the competent authority will only issue one electricity license, operator's license. So when that law entered into force, there was a company in Romania, Opcom, that already had a license issued in 2001 for 25 years. Therefore, it had the monopoly on electricity markets in Romania. in this context, actually it had the monopoly on intermediating offers to sell and bids to buy electricity on short-term, medium-term, and long-term markets, or to use the phrasing in a relevant EU law, intraday, day-ahead, and forward markets. This, just so everybody understands the words that I'm using. In this context, the referring court asked 3 questions to the CJEU. The first 2 regarded electricity, especially if the relevant EU provisions, Regulation 943 of 2019 on the internal market for electricity precluded a national legislation such as the one that I just described. The CJEU said that as regards the first 2 markets, meaning day-ahead and intraday market, no, the regulation does not preclude practically maintaining a national legal monopoly. If that legal monopoly was enforced on the date of entry into force of a different EU regulation, Regulation 1222 of 2015. Or in 2015, when this entered into force, Opcom already had its legal monopoly, so everything was fine on this side. As regards the third market, the forward market, regulation, according to the court, Regulation 943 does not preclude, again, maintaining such a legal monopoly, but it would have to be analyzed also in relation to primary EU law, so the EU treaties. Now, the third preliminary question is the one that touched upon the area of competition, and namely if Articles 101, 102, and 106 of TFEU precluded the type of national legislation that I just described. The CJEU firstly clarified that this issue does not arise for the first 2 types of markets, intraday and day ahead, because since Regulation 1222 already allowed for maintaining the monopoly, there could be no competition problem in this area. So the third question should be only analyzed as regards the forward market. Right here, the CJEU felt the need to recall its constant case law that it's necessary for the referring court to clarify the factual and legislative context that gave rise to its question. It emphasized that in the area of competition, which is characterized by extremely complex factual and legal situations, it is of utmost importance, or even more important, if I could phrase it like that, to give all the details. And in this case, the request for preliminary ruling did not contain any indication as to what had prompted the court to refer this question. It did not state why Articles 101, 102, and 106 would be applicable in this case, or why a national legislation like the one we are discussing could infringe those articles. Right here, I would feel the need to make a personal comment. I do not think I can imagine right now off the top of my head a hypothesis where a company that has monopoly, so is alone in a certain market, could collude with a different company so as to make Article 101 of TFEU applicable. But as regards the other 2 articles, 106 read in conjunction with 102, there was already case law of the Court of Justice stating that these 2 articles presuppose that there should be a dominant position on a significant part of the internal market. There should be an abuse of that dominant position, and an abuse in such a manner that is liable to affect trade between member states. So, because none of these elements could be found in the request for preliminary rulings, especially in this specific area of competition, the CJEU had to declare the question inadmissible. Now, going forward, I would like to change the field a bit and talk about case law very recent case law in tax law area, and especially the reverse charge mechanism. It's case C 146 of 2021, Direcția Generală Regională a Finanțelor Publice București, which is essentially the name of a tax authority in Bucharest. So what was the national litigation that gave rise to the preliminary question in this case? Essentially, a tax authority inspected VB, a company selling timber in Romania, and required it to make a retroactive payment of a value-added tax, VAT, and refused to apply the reverse charge mechanism. The reason for this refusal was that the company VB had not registered prior to making the taxable operations, had not registered for VAT purposes, even though she had exceeded for some time the ceiling, the threshold, under which small businesses were exempt from this obligation. In this context, I think it would be all right to clarify a bit the relevant EU and national law in this field. Article 193 of the VAT Directive states the rule that the taxable person who is liable to pay VAT is the one selling goods or providing a service. This is the rule. Now, Articles 199 and 199 letter A of the same directive provide certain fields where it is possible for member states to derogate and to adopt this reverse charge mechanism, where the taxable person paying VAT is actually the beneficiary, the one receiving the goods or services. Now, the sale of timber was not among these areas. However, there's also Article 395 of the VAT Directive, which allows the EU Council to authorize any member state to derogate from provisions of the VAT Directive insofar as it is necessary to simplify procedures of collecting VAT and to avoid certain forms of tax evasion and avoidance. So, taking into consideration this article, upon request of Romanian authorities, the EU Council issued in 2010 a decision allowing Romanian authorities to have a derogation from the general rule in the VAT Directive and actually include in the reverse charge mechanism the sale of timber, the supply of timber. This is exactly what national law did by Article 160 of the former tax code, which would now be 331 of the tax code entered into force in 2015. The only condition mentioned there is that both taxable persons, the buyer and the seller, need to be registered for VAT purposes. So this is the context in which the National Court decided to refer a question to the CJEU, asking if the VAT Directive and the principle of fiscal neutrality precludes national legislation under which the reverse charge mechanism cannot be applied if the taxable person selling the products was not registered, had not applied or obtained of its own initiative registration for VAT purposes before the taxable operations. The Romanian authorities were not sorry to see the decision of the CJEU that EU law does not preclude such legislation, and I will briefly present the three main pillars on which the court based its decision. Firstly, the court saw that neither the VAT Directive nor the Council decisions establishing that Romania can introduce derogations from the VAT Directive contained any mention that Romania could not establish the mechanisms, the concrete mechanisms for the application of this exceptional mechanism of reverse charge. Actually, because it is an exceptional mechanism, it should be subject to strict interpretation and application. Therefore, the national legislation, because it's clarified and limited the scope of application of this mechanism, it was perfectly valid from this point of view as regards EU law. Secondly, the court admitted that in its previous case law in the field of VAT deduction, that's different a bit, it had stated that the condition of registration is purely formal, and it should not, if it is not met, that should not preclude a right of deducting VAT so long as the material conditions for a right to deduction are met. However, with the occasion of this new case law from June 2022, the court clarified that its former case law actually sought to ensure compliance with the principle of fiscal neutrality by required that the taxable person may deduct input VAT if the material conditions were met. So the right of deduction of the recipient of the supply or the beneficiary must be in principle in the same way respected in the reverse charge mechanism and in the common VAT system. So that right is not affected for the beneficiary if tax authorities refuse to the provider the application of the reverse charge mechanism. Because a refusal to apply this mechanism does not undermine the right to deduct VAT for the beneficiary, it does not undermine the fiscal neutrality. So everything was also golden on this side. Thirdly and lastly, the court recalled that the principle of fiscal neutrality is essentially a translation in the field of VAT, of tax law, of the general principle of equality of treatment. So that similar situations should not be treated differently unless such a difference in treatment is objectively justified and pursues a legitimate aim and is proportionate with that legitimate aim. So in this respect, the CJU could only find that the criterion used was objective. All companies, regardless if they were sellers or buyers, were subject to the obligation of registering for VAT purposes. The aim of the restriction was legitimate. It was linked to legal certainty and legal clarity in a context where the Romanian timber market consists of an extremely large number of small businesses, which the Romanian authorities would otherwise have found very difficult to control. And also, by imposing on taxable persons a condition of registering for VAT purposes, the beneficiary of the transaction finally has an accessible criterion for knowing precisely the extent of obligations of their co-contractor and their own obligations, their own tax liabilities. Finally, the difference in treatment thus appears proportionate to the aim pursued, given that anyway registration for VAT purposes is derives from EU law itself, from Article 214 of the VAT Directive, and of course the right of deduction of the taxable persons in question is not called into question itself. So this being said, because I know we don't have much time to discuss any other case law, I will just say that for other recent cases, we publish on a monthly basis on the website of the Ministry of Foreign Affairs synthetic documents containing summaries of the most important or most interesting decisions of the CJU of the past month, not only in references for preliminary rulings from Romanian courts, but also in different other types of cases. And they are usually grouped by relevant fields so that any interested person can go straight to the area of law that they're interested in and see what is new in the case law. This document is in Romanian, so for those interested of seeing other language versions, more recently the court itself has started publishing, let's call them monthly case law digests, which are also an interesting read. And one final thought. Of course, we have many pending cases right now before the courts, the EU courts, many preliminary rulings. Yes, in the area of tax law, regarding the ways of refunding car taxes that were deemed incompatible with EU law. Also in the area of competition, linked to the extension of concession licenses for exploitation of mineral resources, and in many other fields, consumer protection, etc., etc. Of course, they are still pending before the court, so I could not touch upon them today. But in a few months' time, the judgments will be available to the public, and I'm certain that they will be very interesting talking points the next time we meet, perhaps in a conference similar to the one we are attending today. Thank you very much until then for your patience and your attention.
Thank you. Now, because we have to end somehow, but I think I can address a question to all related to a debate, and I'll start with the construction law and going up to state aid and a little bit to tax facilities. Just to touch a bit of that. It's a debate after the war anyway, and after the pandemic in construction field, we had to come and offer some facilities in order to adjust contracts. We had different acts over there, actually two ordinances, and it's debate if any this considered as a state aid, and also, as I know, it's in the rehabilitation program anyway to be refixed. If you have any thoughts on this on the evolution taken into consideration, that will have actually a reaction in the market, and we're in the Bucharest University of Economic Studies anyway, without giving us too many hints anyway. Now I'm addressing the Romanian persons that are invited, but also anyway, if you have any thoughts on this, in the idea of impact of the pandemic, and of course of the war in this specific industry, because clearly with Ukraine being a main supplier of steel over there and others, that was an issue.
The only thing that I can say now, unfortunately, because I'm not linked to the policy making, I'm just part of the team of lawyers who ensure the Romanian government's representation whenever issues, interesting debates arise before the Court of Justice. I can say that in our area of activity, we have not yet seen major changes as regards the types of cases, the types of situations, the concrete measures adopted by member states in this times marked by new challenges. As our colleagues have said in the first presentation, Ms. Chantal Muldealba mentioned that law usually follows what happens in practice, and as far as new law and interpretations of new law by the CJEU, I'm afraid it at this stage, it has not reached such an advanced point. Any novelty has not reached my area of activity.
Thank you. Yeah.
Okay, so it's very interesting because I talk about giving money, helping companies, and you spoke about how to claim companies who are aid. No? So, as Ovidio said, it's like a contradiction, and probably you will have work with all these aids that are going to be given, because maybe some companies will consider that it's not fair and it's going against the European market, no? So let's see what happens, but there's a field of work, I think.
Thank you, Chantal. Now we have a short break in order to switch from this opening session to the, how we call it, academic forum. So some scholars who are coming here and lawyers who are coming here and present some papers in different matters of European business law. Thank you very much. I thank all the guests from abroad and from Romania, and I hope to see you soon in other of our events. Thank you.